we got left of it. About an hour.
All right, welcome back, ladies and gentlemen. You may be seated. Ready to make your closing statement? Yes, sir. Thank you.
Good morning again, ladies and gentlemen. I know it's been a long 4 days. We appreciate your patience and your attentiveness. You've now seen all the evidence and heard all the testimony that you're going to hear in this case. I told you at opening that I'd come back here at closing and go over the evidence with you. There are some photos that the people did not show during the case in chief. Those will go back with you into the jury room. If you feel like those will be helpful in rendering your verdict, you're free to look through them and review them. The same with the defendant's interview. The people did not play that in their case in chief. The defense didn't elect to play it. I think the parties all felt it didn't move the needle too much one way or the other, but you're also going to be free to view that back in the jury room. So what has the evidence in this case shown? It showed that Diane Medina, Leah Stiff, Ed Smothers, Jaden Phillips, and Mariah Dodds were all injured as a result of the defendant's operation of the motor vehicle. We could bring up the jury instruction on OWI causing serious impairment. And you'll have this written back in the jury room. But the injuries being the result of the operation of a motor vehicle is one of the elements you need to find. That is not in dispute. The defendant was the factual and proximate cause of those victims' injuries. Further, those injuries rose to the level necessary under the law for you to find that element in counts 5 through 9. This is actually stipulated to by the parties. In other words, we agree the degree of injury is not in dispute. Further, you could bring up OWI causing death. The evidence shows that Zayn and Alanah Phillips died as a result of the defendant driving that day. Their death was a factual and proximate result of her operation of the motor vehicle. They do not dispute this. You did not hear from a medical examiner because the parties agree that that was the cause and manner of death. It is not in dispute. The defendant's willful operation of the motor vehicle is not in dispute. The parties agree. We all saw the video of her leave her house and get in her car.
Judge, I agree that there's willful use of an automobile. Tony just said we agree on willful.
No, fair enough. I guess.
I agree there was an automobile accident. It's proximate cause of a horrible thing of injuries and deaths.
All right, your objection is
Fine.
People offer to you that the proof show that the defendant willfully operated the motor vehicle on the date in question. You all saw the video of her get into her vehicle and drive it away from her home. We think that element is met. Her identity as the driver of the vehicle is not in dispute. People would offer that there are two key elements in this case that are in dispute. The defendant's blood alcohol concentration and her intent when she crashed into the Swan Boat Club. As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Rome Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career. And she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, Lab Technician Hopner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond. That typically a blood sample would be dropped in the mail. This one was hand delivered.
One of the witnesses yesterday on day one, had the funniest name. Or was it? It's the one I'm doing, presentation I'm doing at the moment. Maybe it is.
By Deputy, the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecham, testified the procedure for testing the blood and their results. Their results, that the defendant's blood was a 0.18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood.
That will affect it.
But this is disputed. So what can you folks do? What other evidence can you look at to support the expert's evidence of the blood draw? First, you can look at the testimony from the first day of Ms. Sigler and Mr. Wickland. Ms. Sigler testified that she smelled alcohol on the defendant
Sigler.
immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you. In his opinion, she failed field sobriety testing. But how else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Karina.
Two times, 0 being like your so-called sober, you can drive perfectly.
Yeah, she said she was at like level 7.
Where do you think you're at right now? 7. 7?
Yeah.
What else supports it?
I'm
When they tested her blood, they found
having had
gabapentin.
a cattle digest.
What did she tell us about her gabapentin?
Run through the medications that you about again.
Gabapentin,
When do you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Oh,
And how do we know she had more than the one drink at Furnace? It's well established in the evidence, and I don't think either side disputes. She left Furnace at the latest at 12:15. Crash was at 3:01.
Oh, no. I'm back.
But remember what she told Sergeant Bomia.
A little bit less.
when was the last time you had something to drink?
Probably half an hour ago.
That's not really a drink.
There we go.
Why?
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Furnace. That doesn't speak to the rest of the day. All of those other pieces of evidence that I've just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Furnace wasn't her first or her last drink of the day. It's similar to the mystery story I mentioned to you in voir dire, that all of the evidence lines up to show one result, except one thing. And that one thing is defense's expert. But everything else works to show that the BAC result is accurate and in line with what she did that day. The second element that people believe are in dispute is the defendant's intent. We bring up the second-degree murder instruction. For the OWI causing death and the OWI causing serious impairment, you only have to find willful operation of the vehicle and that her blood alcohol exceeded the legal limit, or that she was intoxicated, or that she was impaired by alcohol and gabapentin. For the people's first 2 counts, the 2 counts of murder in the second degree, you have to find a separate intent. You can find one of 3 kinds of intent to find the defendant guilty of second-degree murder. You can find that she intended to kill. You can find that she intended to do great bodily harm. Or you can find she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. As we talked about in opening statements, you can look at what she said, you can look at what she did, and all the evidence and circumstances surrounding this case that you've heard over the last 3.5 days to decide what her intent was. You can think about her driving toward the boat club, straight as an arrow, right between those 2 telephone poles. You can think about what she said to Kristen Sigler right after the crash. Where's Don? She wanted to know where her husband was. You can think about her crashing into the neighbor's truck. And then continuing on her way. At the moment she crashed into that truck, she had to know things were not right, but she continued on. She continued on at full speed and drove her car into a 3-year-old's birthday party, into a building, a route that she knew very, very well. Ladies and gentlemen, this is not a typical drunk driving crash. Not at all. She didn't cross a center line and strike oncoming traffic. She didn't misjudge a red light and rear in someone. At almost 45 miles an hour, she drove through the wall of a building that she had been to countless times. That's what makes this worse than OWI causing death alone. She drove her car into an occupied building knowing she was unfit to operate a vehicle. And if she didn't know she was unfit to drive when she got behind the wheel, she knew it after she hit her neighbor's truck. Five, 4, 3, 2, 1. 44.3 miles an hour on a dusty, pitted dirt road. Look at all those things to determine her intent. As most criminal trials are, the focus of this trial has mostly been on the defendant. How she drove, the contents of her blood, and her state of mind. But let's not forget, a trial is about a fair trial for the defendant and for the victims. The ones you heard testify and the ones you couldn't hear testify. It's about an 8-year-old big sister and her little brother. 2 little kids that had just sat down to eat their hot dog and a cake pop at a birthday party. Sat down to have some lunch without a care in the world. They didn't have a chance. It's about justice for these 2 kids. Thank you.
Thank you. Mr. Phillips. Thank you.
This is the law in Michigan says that the plaintiff, the prosecution has the burden of proof. That's why they get to go first. That's why the defense goes second, because they don't have to prove anything. These people have to prove everything, every element beyond a reasonable doubt. And then because they have such a high burden to prove their case, they get to go first for a closing argument, that's what this is called. And then I do my closing argument as a defense. And then because they have such a high burden of beyond a reasonable doubt, they get to go again. They get to go last. So, and it's sort of common sense. We can't keep going on and on for many days. So they stop it there at the law. So they get to go first, then we go, and then they get to have closing argument the last. And sometimes what happens is that they'll do their closing argument, and then they'll say something that I can't rebut or I can't stand up and talk like I am right now, I'm going to be doing with what they mentioned. So I ask all of you, when you go into the jury room to deliberate, think about what Bill Clovis would have said. Think of how I would have countered anything if they're holding anything for their last time to talk to you and I have to just sit there. This case, I don't have to tell you, it's very, very it's very sad. It's very, very sad. And the facts of 2 children passing away, as a prosecutor said, in a setting like this is just beyond grief. And that's why I took a moment out, maybe took my attorney jacket off, so to speak, and really gave sympathy to Mom. I give sympathy to all of them. I don't want anybody hurt. I don't have vindictiveness. My client doesn't. And I gave my sympathy. And it's normally out of line to do that. And I'm glad the judge and prosecutor allowed me for a minute to do that because I just had to get that off my chest or myself because I can't talk to the witnesses here when we're in court. And they don't have to talk to me at all. It's very, very sad. And, you know, I'm taking a little bit longer in a closing argument today than I normally do when I have a trial or I'm involved in a trial because there are several counts. Well, first, all due respect to everybody injured and the poor little kids. I'm going to show them respect. And that's why I want to just talk to you. I'm not making things up. So many times, attorneys, people raise their eyes or look up when you say attorney or attorney jokes and that. There ain't no joke in here. And I'm a real deal. When I talk to you, I'm not making anything up. Certainly, it's up to you. You're collectively the judge of the facts, all of you. And I respect that. And my client respects that. That's our American jurisprudence, our American law, is that we have, if you're charged with a felony, especially a capital felony, 12 jurors decide the case. So the judge certainly has been very nice and will release one person, and the clerk will. And then the 12 of you, whomever you may be, will deliberate and rule on the case as a judge of facts. Of course, the most serious part of this case is second-degree murder. Murder charge don't get no more serious than that, at least in Michigan. A murder charge. And to me, in the law, is that for somebody can get charged every day for whatever. Somebody to be convicted of murder, whether it be second-degree murder, there's an intent. There has to be an intent, or intentional, like recklessness. To me, that's intent. Okay. If I'm driving down the street on the freeway and Bill Clovis never had a heart attack, and I have a heart attack, and somebody's changing their tire, and my car hits them, they die. There's not much intent there. I had a heart attack. What do you want me to do? I apologize. Everything that happened, but please don't charge me with murder. Okay. And that's our first part of the poor two children that died. And my client, actions speak louder than words. My client, the officer says, in effect, had no record. Well, nothing.
Objection, Judge. I think he's arguing facts, not evidence.
Well, I thought I asked the officer with regard to record. If I didn't, the jury heard me not ask them that.
All right, we'll allow it, but it's
Thank you.
a close call.
Thank you. This person doesn't drive around committing crimes. Here's this person that went to lunch. Let me back up. I want to address everything they brought up. But it's interesting that some of the things they brought up was not what they call a case in chief. In other words, when you present a case, as a prosecutor, you put everything up there.
I absolutely 100% agree, Celestial Force, but obviously you didn't see the start of this trial. Yeah. They have CCTV footage of her coming out of her home, walking, stumbling to the car, getting in the car, putting it in reverse. She got about 5 foot out of the driveway and then pedal to the metal, reversed into another car, didn't stop, put it in drive, took off like a bat out of hell. 500 meters later, she hits this boathouse and kills 2 children. Because when she hit the first car, when she was reversing, airbags got deployed and the car recorder started. Event detection recorder, or EDR. She did not stop accelerating at all. There was no time at all that she put her foot. Well, there was 1 second she must have just quickly tapped it, but she was still accelerating for the 5 seconds before impact. She's claiming that she had a seizure, but you don't have a seizure, reverse into a vehicle and then change gears and put it in drive and drive away. Sorry. It doesn't happen. Yeah, sorry. She's as guilty as... Yeah, no worries, sweetheart. It's, I did a, like a case overview at the start, and it's in day 1 anyway. You'll see them all, but it's horrific. It shows every angle from both outside the building, from the neighbour's house, from inside the building, with the CCTV footage from inside showing the car coming in, and yeah. and the carnage afterwards. So just trigger warning. She should never have gotten to trial at all.
Then the defense puts, if there's any evidence they want or whatever to counter it or bolster their defense, then they go up there. That's how it's done. Then they waited and did some rebuttal and pulled things out of wherever. Why did they bring that in case in chief? If it's so true and so positive.
Does it have
to
something
think
for
about.
rebuttal?
Is it lawful? Yes, they can do that in rebuttal. But think about common
That's
sense.
a whole lot of
That's another
rebuttal.
thing. You don't, a lot of times judges will tell juries, you don't leave your common sense outside. You leave your
No,
bias
exactly.
and prejudice outside, but not your common sense.
Exactly. That's why when you have a receipt for 5 bottles of wine at 9:01 that morning, and there's an empty one in that center console, just because no one saw her drink it doesn't mean she didn't.
Just you can have your common sense when you're in the room. That's what we all have, our life histories that we bring. That's why I like to have a little bit older jurors, because they've experienced life histories. And they can judge things because they've lived some life. And you can use that. You just can't have prejudice or bias. You can't have that. Somebody sitting at the defense table, they're guilty. Prosecution prosecuted my brother. I don't like prosecutors and police. No, can't do that.
Innocent
You got to
until
start with a clean
guilty.
slate. Just as if somebody, anybody, family member,
No.
whatever, is being charged with something. You want them to have just a fair, clean slate to start with. That's why I asked in the very beginning.
Until you watch that video, yeah.
There's nothing been said. How would you find the person? Sometimes people say, well, they're charged guilty.
Poor mother was in a coma. She was that badly injured. She lost 2 children, and her 3rd child was airlifted to another hospital. She couldn't see him because he had so many fractures. The last child, she had 3. 2 of them went that day. Sorry, not good enough. This woman shouldn't have had a license. If she was having seizures, she shouldn't have had a license.
No, not in America. They haven't put any proofs on it. They got to prove their case beyond a reasonable doubt. Every element.
And they have.
With regard to going, and they held for a rebuttal, this Fermi 3 or whatever party store, corner store, and there's this, she bought some stuff for the house, some wine and
Some stuff
these
for the
photo
house, was
bottles
it?
of whatever,
Not
soda
a
or
liver,
whatever.
just a house.
There's nothing illegal about that.
Exactly.
When she went in there, I asked, is she sober? Is she okay? Yes. Would you
Yep,
sell to somebody
I
else?
called for
No,
this.
thank God. I like to hear that. And okay, so
Right
we've got
there.
that they brought. And then we've got her going at 11 o'clock to
You might need a
Furnace
bit
Tavern.
quiet on this one, I think,
Okay.
actually. Hang on.
Did she drive there okay?
Where is
Yes. She had an accident. She turned the corner, go down the road, country road, veer to the right.
For a while.
Everything okay?
Okay.
Touche.
Mm-mm. 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 Mm-mm.
Mm, 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 mm.
Mm-mm.
Yeah, but also the officers aren't telling us. They're telling us anything. They went and looked at something she bought at 9 o'clock or 9:05 in the morning. So, okay.
Yeah,
So if it doesn't exist, that's a positive for my client.
we didn't
Remember
see any
that.
doctor's
We're going to
record.
bring up every negative there could be with a microscope.
I have a
That's why
banana,
it's
sorry.
We're going to bring up positive or talk about their negative, credibility wise. So, okay, so then she drove at about 11 o'clock to Vernon's to meet 2 friends for lunch. She says a sandwich. They say no. Sandwich, you'll see the receipt as an exhibit. Take a look at it. Looks like my client had a better memory on the food part. And so she had the chicken chili or whatever. And she also had 1 glass of wine. And
Top up.
Verna, the person, Kelly Thornton, that came here, and I'm told that she's like really a peppy person, but she was very sick that day. And, she was, and it showed. She did not feel good. And I'm glad she showed under subpoena. And she testified that she was sober. When she came in, she was sober. So
and-
if the prosecution
I've created for the presentations that I'm going to be starting to do, I have created a new segment. Yep. You want to see? It's called Let's Get All Up in Show Business.
Let's all get up in
Go back to start. And play.
Let's all get up in show business.
Yep. New segment. Look out for it. It's coming your way.
She's trying to say that she guzzled all these drinks and then went in there. You're wrong. Actions speak louder than words.
Uh-huh.
You can talk all day long.
BIC.
Prosecution wasn't there. The police weren't there. All they're doing is surmising. And they're trying to surmise beyond a reasonable doubt. And they're trying to throw out facts like these two children
Blood test
passed
don't
away
lie.
at a party. Absolutely. I feel horrible. That doesn't make somebody automatically guilty. You have to prove it. We don't go by emotions. So she comes in. The testimony of Kelly Gordon is she's sober when she comes in. It's just normal.
No, you're an
She
alcoholic.
met friends, had lunch, had one glass of wine. Any other wine? No. Anything else to drink? Water. Okay. And the bill, she got the bill. They each got individual bills, whatever was paid by credit card. Thank God. There's a record of it. Exactly what my client said. And when I first met my client, she said, I had one glass of wine, Bill, at Verna's when we were in Verna's, because I said, what did you have at Verna's? She said, one glass of wine. And, you know, as a defense attorney, you listen to clients, but until it's backed up with something, either paper or something, you don't automatically, I hear it. I keep it in my head. I hear it. And then when I see the search warrant that they immediately used, closed it off, nobody allowed in immediately, because she told them, I went to Verna's, where were you before? Verna's. They went there, they use a search warrant immediately, and they get the receipt. And you'll see that's one of my exhibits. I only have like 3 exhibits, A, B, and C. I keep it simple. And that's one of the exhibits. If you take a look at the defense exhibits, got a little delta or a D.
That's because you've got nothing else to give.
And so that lines up perfect. She's trained, she said, for 20 years. She has regarding alcohol and looking, observing, and the effects of alcohol and seeing if somebody might be under the influence, not to serve them. And she didn't. And she felt she was totally fine.
Well, she'd lose her
when she
license,
left, was
wouldn't
she
she?
fine? Okay. What did she buy? What did she drink extra? Nothing.
Responsible service of
Okay.
alcohol.
So we know that's solid. We know that before 11, it's solid sober. Then we know at
No, we don't.
12:15 when she left, solid sober.
No, we don't.
In America, in Michigan, you're allowed to have a glass of wine. You're allowed to have a glass of wine. And she ate.
So the 0.18 BAC just miraculously appeared out of nowhere, did it? Just poof.
Okay. And she just miraculously was able to drive home and go through the country road and branch off and turn and take the angle and do all that,
Yeah,
not
she
get
left
stopped,
the bottles in the
not
fridge.
have a collision, not fall off
Going home for a
the
tipple.
road and go into, areas that are not the paved road. And she was able to park her car. These are all things of sobriety. That's what we look at. Wasn't parked on an angle. She didn't hit people
But when
coming
she
home,
left,
hit people, the neighbor. So then she gets home. She's home for a couple hours, let's say 12:15. She goes up to the birthday party at 3:02 or thereabouts. She was leaving 3:01 in the afternoon. So 12:30, 1:30, 2:30, about 2.5 hours. Then they
And how much
say
wine did
their
you polish
proofs, well, and they wait that video. They wait until rebuttal.
don't forget, what time was the bloods taken? A couple of hours after that, after the incident, at least. So at point of impact, she would have been well above that.
At their case in chief. So I don't know what was in their mind. That's up to you. I don't know if they thought that maybe it's not as strong or doesn't make sense, but they waited till rebuttal. That's up to you. That's your area.
Yeah, because that was the kicker.
Okay, it's all about credibility. And so that's when they bring up and say, well, look,
They brought the receipts,
look at what we
did you?
found. Look at what, we got a video here. Let's call, the officer back up here and
What?
talk about a video that shows that she's walking.
What? What do you mean? Can you not see the video? Really? Let me take it off and add it again. How about now? Yeah, the video's on stage. Can you see it now? Ah, I just took it off and put it back on again. Sorry, doll. I'll go back a little bit so you can hear what he was bullshitting on about. Because
that I hear. And then when I see the search warrant that they immediately used, closed it off, nobody allowed in immediately because she told them, I went to Vernus, where were you before? Vernus. They went there, they use a search warrant immediately, and they get the receipt. And you'll see that's one of my exhibits. I only have like 3 exhibits, A, B, and C. I keep it simple. And that's
Show
one
it
of
on
the
my
exhibits.
screen,
If you
sorry.
take a look at the defense exhibits, got a little delta or a D, law school, that's what we use.
Did you see my business intro? Maybe that's what stuffed it.
And so that lines up perfect. She's trained, she said, for 20 years. She has regarding alcohol and looking, observing, and the effects of alcohol and seeing if somebody might be under the influence, not to serve them. And she didn't. And she felt she was totally fine.
So did you actually see the video of the intro that I put up or not? No? Yes? Anyone?
When she left, was she fine? Okay. What did she buy? What did she drink extra? Nothing. Okay. So we know that's solid. We know that before 11, it's solid sober. Then we know at 12:15 when she left, solid sober.
No, we don't.
In America, in Michigan, you're allowed to have a glass of wine. You're allowed to have a glass of wine. And she ate. Okay. And she just miraculously was able to drive home and go through the country road and Branshaw and turn and take the angle and do all that, not get stopped, not have a collision, not fall off the road and go into, areas that are not the paved road. And she was able to park her car. These are all things of sobriety. So we look at it. Was it parked on an angle? She didn't hit people coming home, hit people, the neighbor.
Okay.
So then she gets home. She's home for a couple hours, let's say 12:15.
Down
She
to
goes up to the
couple
birthday
of
party at 3:02 or thereabouts. She was leaving 3:01 in the afternoon. So 12:30, 1:30, 2:30, about 2.5 hours. Then they say there are proofs, and they wait that video. They wait until rebuttal in their case in chief. So I don't know if they.
Oh,
I don't
I
know
waited
what's in
till
their mind.
rebuttal
It's up
to
to
show
you.
their
I don't
receipts
know if
for
they
the
thought
pub.
that maybe it's not as strong or doesn't make sense, but they waited till rebuttal. That's up to you. That's your area. That's your bailiwick. Okay? It's all about credibility. And so that's when they bring up and say, well, look at what we found. Look at what, we got a video here. Let's call, the officer back up here and talk about a video that shows that she's walking around. Okay? She's got that, whatever. And, maybe she's drinking. Okay? All right? And then she's not falling down. She's not tripping. She's not dropping things. But, maybe she's under the influence. Well, maybes don't convict. Maybes not beyond a reasonable doubt. We don't do that here in America, maybes. We don't send somebody away. Murder too.
We don't ignore blood alcohol concentration
Maybe.
levels
Okay?
either.
So then this collision happens. And you say, you know what? That was just crazy. Okay? You're right. It was crazy and completely out of character. Somebody's never had anything. And that makes me think that something neurological, that there's been talk.
Yeah, neurological for sure.
And
Central nervous system.
that she went back driving out of the driveway and went in reverse. She hit. And then hitting, the arm came back and went full speed ahead.
Really?
And there's
You kidding me? Did you hear that? Was it a manual or an automatic car? Does anyone remember? They're saying that the impact of her reversing and hitting the other car jolted her arm and put it into drive. I'm sorry, but this has to happen. Sorry.
saying the prosecution for a murder too, that she intentionally did this, that she had this intent, this reckless intent to kill somebody.
She had recklessness for
Okay.
sure.
Former Commodore.
Yeah, disregard.
Reckless intent to kill someone. I swear, and I swear, there's no intent to kill anybody, much less two
What
little
was reckless
kids.
disregard for human life?
There's no intent to hurt anybody. Why would you put it to the floor? Why would that person testify that it's brake and gas for a second there? Both. Where'd that come from? So, you know, when I'm working on this, I put a lot of days and hours in. When I'm working on this at my office, you know, I'm looking at just, it don't make sense. Out of nowhere, somebody's gonna put it to the floor. Somebody's gonna put it to the floor and go right into a building that's 450 feet from her house. She's a former Commodore. She lives on the street, lived on the street forever, married, you know, whatever, long time. So they're,
That bad equipment that Judge Nichols says. Good.
Judge, people don't understand, the court reporter has more power than the judge, because when that goes out, the judge has to stop shit. That's true. I know. That's why we treat them with great respect. This sort of lost me for a second. You know, put it to the floor, and she's going to, they would say, is that she intentionally caused this recklessness. She intentionally wanted to go into the building. I don't know where that comes from. I have no idea. Yes, I understand what the video shows, but an intent to do that, that's insane. That's crazy, with all due respect. So then, while I'm working at my office and I'm going through things, we start getting voluminous records. And, you know, you were told it was, I don't know, I thought it was 200 pages, but he says more like 300 pages, you know, of going through all the records with the state of Michigan and their history and their certification of the machine and this and that. And also all the records of acetone and all the other things that show up. And it's interesting that, and this is real pivotal part of the case, is you want that blood to be as pure as humanly possible for testing. Why? You got murder too, 2 charges. You have other charges that are extremely serious, under the influence causing serious injury. These are all very serious charges, very serious felonies. So you want everything right on the money, absolutely as perfect as human can be. So why would I not? Doesn't cost a penny, and you do it every day with drunk drivers. As a road patrol officer, why wouldn't you take him to the station? Get a breathalyzer flown. It's also closer in time. Have that done. Doesn't cost anything. Then you got the data master, whatever they were using back then, the breathalyzer. Okay, you got those results per hour. Right then and there, not an hour. Right then and there, immediately when you're blowing. 2, to confirm the first. If they're too far off, a third. Why would you not want to do that? Number 1, you've got fatality. Okay. Number 2 is, why wouldn't you do, and he talked about a urine test. I'm not saying you got to do one of those, but at least a breath test, but you could do a urine too. That's what the law says. That's what that DI 177 that he talked about, that he read, which means the right to refuse it, but you can take all these things. My client says, yes, sign. You don't even need a warrant. They got one anyway. I'll sign. You can take whatever blood you want for testing. Does somebody guilty do that? Does somebody feel guilty do that? Somebody's scared and they're under the influence. Do you do that? And I'm talking about to be a 1-8. Does somebody sign and say no? Or yeah, go ahead and take my blood or my urine or whatever? No, I don't think so. Again, we can use our common sense on this. So they do that and they wait, I said, a couple days and take it to Lansing. And then I'm very thankful they have a video of the person drawing the blood. And you know what? That speaks for itself. All of you saw that. And that's why there's 12 ultimately, because sometimes you catch something somebody else didn't catch or whatever and talk about it. And what's really great is you can ask for those videos from the bailiff to the judge for any of those videos. And they'll be, the judge put together very nice.
All right. Reckless disregard. It's somewhat redundant legal term that's used in many courts to discuss the intent of a person who is charged with a crime. Intent has to be established in order for a criminal case to be successfully prosecuted. And one of the ways to establish this is to propose that a person was reckless. They can also have done something purposefully, negligently, or knowingly. Each description means slightly different things. When someone acts with reckless disregard, they commit an act they know is probably illegal and that could harm people, but they don't have an actual intent to harm a person or people. The idea of reckless disregard can be a bit confusing. If a person behaves recklessly, disregarding the law, there's a clear inference that he might harm others. The drunk driver who climbs into a car could be accused of behaving recklessly, for example. The driver doesn't want to hurt anyone, but the very fact that he is drunk makes that scenario much more likely. It's sometimes argued that the drunk person is acting in a knowing or purposeful way, because most reasonable people are aware that the incidence of car accidents increases when people are driving in an intoxicated state. Still, the basic intent is to drive the car. Though this breaks many laws, it's not to kill someone with the car. Therefore, it may pass the test of being considered reckless disregard. Yet, this does not mean that the drunk driver is any less culpable. That someone is behaving recklessly can be used as a defense against crime. A small reckless act might have some weight when a person receives a sentence, but most reckless acts, especially reckless disregard for human life, are treated abhorrently by the court. No court wants to hear the tragic case that involves death or suffering of others when such acts could have been prevented. Reckless disregard may establish that a person did not have specific intent to harm, and this might suggest different charges. Murdering several people on purpose and murdering them recklessly could look very different. It depends from jurisdiction and regional laws. Usually the person acting with reckless disregard knows that he or she is breaking the law and may possibly be endangering others. The test of knowing is usually based on what the courts think a reasonable person could have concluded in the situation about their actions. Being reckless is the opposite of being reasonable, and the tendency towards reckless behaviour that is criminal is ultimately an affront to society and worthy of prosecution. Right.
Exhibit list of the video, so you don't have to look at all videos. You can pick out what you want to see, which is good. And so you'll be able to see, did she shake it? Did she invert it 10 times? Because it doesn't cost anything to invert it more than once or twice. But I sort of, with all due respect, I sort of got the gist from her that she was okay with the prosecution, but if I started asking her anything, it sort of went downhill the attitude-wise. I don't know why, but I have no idea. I thought I treated her very nice. But it just seemed like she was not happy to be here.
What are you blubbering on about
All
now?
I did was ask a simple question. But that's up to you to judge that, because you can judge credibility, attitude, truthfulness. You can do all that. That's what you are. And so when I started asking her, well, whatever, and she said a few times, whatever, and then I said, well, the video showed one or two, it was done. And it wasn't even done like that. She said, yeah. Okay, so, sort of truth serum comes out when you tell somebody, well, there's a video and it says this. What do you think? Well, yeah, it was one or
like
two.
a video of a car
So
driving recklessly.
that's done. And the preservative is extremely important. Why am I hitting this so much? Because that's their case. Again, that's why I said, why not take a breathalyzer? And that. Nobody says not to do blood. If you're going to do blood, do it correctly. It's very important. So it sounds like she does, like she said, hundreds or thousands or whatever it was, and she just, it's another day here, whatever. Well, there's 2 murder, 2 charges, by the way. So that's done. It's packaged and it's driven up a couple days later, whatever it is. And it's tested. And testing it, and they agreed. The toxicologists or whatever said, your test results are only as good as what you're testing. If it's polluted or it's not good, then your results are not good. Yes, they can come in all day long and give sworn testimony and say, it was a 0.18. I don't doubt that. I don't doubt that that was the result. But how did you get the result? Was there a problem with the fermentation?
Nice.
And something that really sticks out, other than, well, you didn't shake it, so there was fermentation, and here's Bill Clovis, he's coming up with something off the wall, that it's too many maybes there, and it won't overcome beyond a reasonable doubt. No. We've got proof positive. Very thankful that they have proof positive of a graft. I want you to take a look at, I believe it's defendant's exhibit C. I believe it's C. I only have 3. So take a look at that. And it'll show that it's more than a little bump. Take a look at it and see if it goes up like this. Acetone. That gas came out. And then they'd have you believe that the state of Michigan says it's okay to have acetone. It's all right, that commercial cleaner. A little bit of that doesn't hurt you. Insane.
God.
And we come up with something better than that. But it's okay. Nobody gets hurt by that. Oh, okay. Have you done ever testing on live human beings with acetone? I don't expect they have, at least this generation. So acetone, and then my person, who to me came across very professional, very, in my opinion, you're the judging on the credibility of people. But
You're not doing them any favors,
he was
man.
credible. He wasn't sarcastic. No matter if the prosecution or myself asked questions, he was honest. And acetone, he said, nail polish remover. That's what acetone is made up of, industrial solvent. And what happens is, nobody says anybody put that in the blood sample, but it occurs through fermentation. It occurs that way, or something was polluted. The needle, before it went in there, had something, a microbe or whatever. We don't know. But I don't care how it got there. It shouldn't be there. It shouldn't be there at all. And if it's there, it just spoiled the results. These results are supposed to be positive and clean and accurate. Accurate, in my opinion, you're the finders of fact. Accurate, in my opinion, accurate is out of 100%. You can get it up to like 95. That's accurate. You start going below that, there's a problem there about accuracy. It's not a 51%. To me, that's not accurate. Okay. Again, we draw it back to murder 2. 2 charges of murder 2. And operating under the influence causing death. And operating under the influence of causing serious injuries. Counts there. Alcohol has to be right on the money. And I know I repeat a couple things that just because of the seriousness of this case, please excuse me. Where's the breathalyzer? Wouldn't it cost anything? Wouldn't have it been amazing if the breathalyzer said 0.01 or 0.02 and they're claiming 0.18? Boy, they'd have a lot of questions to answer. But you know what? The less testing you do, the less tests you have, the less defense attorneys have questions to. Right? Right. So we don't want to have too much. Plus, remember, they're the ones in charge. You can't say, you know what? I want to go here. I want to go to a doctor. I want to have this or that. You can't say that. Why didn't they have the hospital do it? They had insurance. Why didn't they have the hospital draw some blood? Just for the heck of it. They didn't have to worry about transportation, fermentation, nothing. Boom, it's done. Oh, by the way, I forgot about refrigeration. And it's supposed to be refrigerated. Might have an expiration date, but milk does too. And if you put it outside, not refrigerate, guess what? Who cares about the expiration date? It's spoiled. Spoiled milk is the fermented. That's literally, it causes curds and stuff. I left some too long in my office and it stunk up the office and the refrigerator. Baking soda had to be put in. Fermentation is a very strong animal. It's very strong and it's aggressive. And you don't want that because you've got all these serious charges, including murder 2. I want to know, if I was on a jury, that everything is properly done and there's no question whatsoever. And beyond a reasonable doubt, it's pretty close to that. That where we're at is that there's no question that it's there. All the elements are there. Everything was done properly. If things were not done properly, please don't feel that the seriousness of what occurred, I can't say not guilty. That's not fair. No. That's not what the law says. The law says for you to do your job, do your duty as a citizen, as a sworn-in juror. And that is, if you feel that somebody's not guilty of all the elements and the people have not proven it beyond a reasonable doubt, all the elements crystal clear, then your duty is to say not guilty. And you say, oh my God, these people are going to be mad or they're going to say this. No, you don't do that. In America, you rule, just like the judge has been ruling. He rules. You rule too when you deliberate. Please. Your decision is your decision is going to affect my client's life.
Well, we've got about
And
5 minutes of this left, and
I know
then
by looking at all of you, and I've
Ah,
had a few
don't-
trials over the years,
then we'll go straight
that
to
you've
the
taken
verdict.
this very, very serious.
Go for it.
Very serious. And I truly mean that, or else I wouldn't say it. I've had a few juries, and actually, honest to God, some people will start nodding out. They'll start going to sleep. And it's like, I got to speak real loud to wake them back up from over here. And that's sad. That's really sad. And this was supposed to be a long trial initially. You know, picking a jury, you don't know if it's going to be 3 hours or 3 days. And we moved along very well. And everybody came across very honest. I think that's how we were able to do it. Plus, the judge is really good, if you haven't noticed, about keeping us reined in and moving the case along. I love that he starts at 8 o'clock, because I've been in other courts that say 8:30 and they show up at 11, the judge. So this one I can count on. That door is going to open at 8. And that's good, because it's taken a lot of time out of all of our lives, but more importantly, we do this for a living, out of your life. And I truly want to say thank you.
Oh,
And I
shut up.
truly say thank you for being here, for
Can't blow any more
uprooting
smoke
your
up their
whole
arse,
lives. I don't care if people are retired at home, you're still uprooting your life. And lastly is that we've put such a heavy burden on you. We have a very heavy burden on you when you make your decision. However you make your decision, I will respect it. But you've got a heavy burden, and everybody has to go on living. But I want to thank you
Send those
again
two poor kids.
for taking the time out to be here. There's areas I didn't cover just because you listened to everything. You saw everything, the testimony, videos, exhibits. So I'm not going to go through every single piece. I've gone through enough, but it's my one time. I don't get a second time. If he does go up, Mr. Lorraine or whomever, please try to think what Bill Clovis or the defense would say in counter it. Okay.
Oh.
Thank you very much again. I appreciate your time today.
Thank you, counsel. Brief rebuttal. Absolutely.
And right there, Tricia, can you not pick the difference in caliber of attorney between Action Jackson and this big here?
Folks, I don't have a long pre-planned rebuttal or anything like that. I'm sure you're happy to hear that. Just like to hit on some things Mr. Clovis spoke about in his closing. Why didn't we
Why are you
play
standing
those
with your
videos
arms
and
like
bring the
that?
Fermi clerk on before rebuttal? Because that's not how the prosecutor's office proves drunk driving. We prove drunk driving through the blood result. Once Mr. Clovis wanted to challenge that, I have what I believe to be other evidence of alcohol consumption. I'm going to play that for him. I'm going to show that to you. If he hadn't presented a case, I wouldn't have presented that evidence because I had a blood result. I agree with him that actions do speak louder than words. Her actions at Vernus. But that's the testimony of a waitress who saw her for a minute at 11 o'clock. I think she testified about 3 times that she did not see her leave. Countered with the testimony of a bartender who saw her immediately after the crash, and 2 police officers who dealt with her. Police officers specifically trained in spotting alcohol consumption. I also agree with Mr. Clovis that maybes don't convict. They do not. But you know what does? Lab results, videos, injured people, and deceased victims. The intent in this case was sealed. The second she put that car back in drive and continued down the road. He characterized it as intentional recklessness, but it's exactly what is written in the jury instruction. And look at that. It is creating a situation. Once she starts to back out of her driveway with that blood alcohol content, that's the beginning of it. If she had run someone over right then and there, that's OWI causing death. What she did, that's second-degree murder. She knew from that second she was dangerous. She was in a situation where she was creating a high risk of death, and she continued on anyway.
And he didn't care.
Mr. Clovis talked a little bit about beyond a reasonable doubt. The judge will explain to you what beyond a reasonable doubt is. What the jury instruction says is it's a doubt that grows out of reason and common sense. It's a doubt that grows out of the evidence or the lack thereof. So again, as I did in my opening statement, on behalf of the victims, on behalf of the people of the state of Michigan, when you go back in to deliberate, I ask you to look at everything, speak amongst yourselves, deliberate as you see fit. And when you're finished, find this defendant guilty of 2 counts of second-degree murder, 2 counts of OWI causing death, and 5 counts of OWI causing serious impairment. Thank you, folks.
All right, okay.
Closing arguments are underway in the trial against Marshella Chidester. The 67-year-old is charged with second
with that verdict, guilty on all counts. Take a look at some video. Of course, this was
Holy crap. Yeah. Stop. Freaking hell. Okay. Now,
deliberated for less than 2 hours, coming
Less than
back
2
with that
hours.
verdict, guilty on all counts. Take a look at some video. Of course, this was in court yesterday. They went into deliberations around 2 o'clock, 2:30. Definitely a very emotional day. And as you said, this happened last year. This Monroe County woman drove straight into a kid's birthday party, driving approximately 45 miles per hour with a blood alcohol content of 0.18. She had been drinking prior to the accident, or crash, I should say, at a bar. She had 1 glass of wine there, but detectives proved that she drank beforehand and after. So throughout the day, starting around 9:30 in the morning, all the way until that crash, which was after 3 o'clock that day, killing 2 young children, Zayn and Alanah, and of course, injuring their mom, their older brother, and several other people. This is what the 2 younger children's dad had to say. Take a listen.
After I leave here, I'm going to their gravesite and let them know how today went. I will never get peace. I never will find peace with this. I believe it does close the chapter on this whole trial that's been done. I believe that when I look back at it, everything that came out, I believe that it was right. I believe everything is good.
Now, Chidester was remanded to the Monroe County Jail. Now, initially after this happened, she was arrested. She was in jail, but then she was able to get out. She posted bond. So she's been out for the past year almost. But of course, now in jail, and then she will await her sentencing, which is scheduled for May 15th.
There you go. All right. Now, there was another video that I just saw before this one.
Deliberated for less than 2 hours, coming back with that.
Now, where did I see it? It's just popped up again now. Guilty on all charges. There was a video of inside her house. Where did I see it? Here, I think. Nope. Oh, it was court. Nope. Where the frig did I see it? Come on, it was just here. Two. Was it? Yes. There we go.
Sergeant.
All right. Share this tab instead. There we go.
You testified previously that you executed a search warrant on defendant's home. Is that correct?
Yes.
And when was that to proffer next, Judge?
All right. Let's do that.
Can we play 38A, please? 1 second. Don't play it just yet. Detective, can you, for me, tell me what the date and time is on this?
So the original date and time is 4/20 of 2024 at 8:24 and 47 seconds in the morning.
And so that would.
I'm going to capture this And I'm going to zoom in on it and see if I can find any bottles. Where is it? Okay. All right.
Actually be what time?
9:24 and 47 seconds.
AM.
AM.
Okay. Please play the video.
Oh. Well, I've got these things again. What the fuck?
Please play 38B. Or actually bring it up. Detective, what is the timestamp on that?
9:24 and 38 seconds AM.
What would be the accurate time then?
10:24 and 38 seconds AM.
Please play the exhibit.
So she's a smoker too. The ashtrays on the table.
Please pull up 38C. Detective, what's the timestamp and date on this one?
9:45 and 12 seconds AM.
Also from April 20th?
Yes.
So what is the accurate time then?
10:45 and 12 seconds AM on the 20th.
The bottle of wine. You had that little bottle of wine in her hand. 9:45 in the morning. Got another one?
Please pull up 38D. Detective, what is the date and timestamp on this one?
April 20th, 2024, 11:35 and 1 second AM.
And what is the actual time?
This is just
accurate
before
time?
she goes out for lunch.
12:35 and 1 second, and that would be PM.
Please play the video.
Your Honor, for the record, this is 38D.
That's correct.
Okay.
Got another bottle in her hand. See, left hand. Yeah. I'll put it most likely at the front door.
Please pull up 38. Detective, what is the date and timestamp on this one?
April 20th, 2024, 1:10 and 38 seconds PM.
Home.
It says 13:10, but that is,
From lunch.
the translation is 1:10 PM.
I'm sorry, yes, that's military time.
Sure.
So when
What is the accurate time?
That would be 14:10 and 38 seconds or 2:10 and 38 seconds PM.
Thank you.
There, just for the record, is 38E.
He is in here.
Thank you.
Box in her hand. Another glass. Glass of wine. Red wine. What in hell took them 2 hours?
Let's pull up 38F. Detective, what is the date and time stamp on this?
April 20th, 2024, 13:31 and 50 seconds or 1:31 and 50 seconds PM.
And what is the more accurate time based on timestamp inaccuracy?
It would be 14:31 and 50 seconds or 2:31 and 50 seconds PM.
Approximately 30 minutes before the crash.
Correct.
Please play the video.
And she was probably going to the bottle shop, truth be told. Oh, well, I've emptied it. Uh-huh. Yep. There's a bottle on the bench there. Let's cover up. Are you shitting me? Are you shitting me? And she looked her attorney in the eye and said, I only had one drink. So she was drinking from 9:30 in the morning.
Judge, people again move to admit exhibits
Oh, there's more?
38A through 38F as in Frank.
Response. Your Honor, we have no objection, just for the record, prior motion was filed prior concerning this, but no objection.
People's 38A through F, they are admitted.
I have no further questions for this witness, Judge.
Cross?
That's fucked. No, I hope not. That's fucking disgusting.
Officer, did you,
And he's going on about bubbles in a
were you
fucking
ever
jar.
inside my client's
You don't
home
need a BAC for that.
prior to the date you executed the warrant?
No.
And when you obtained this videotape, you obtained the contents of the videotape, correct? Or the video machine or recording machine?
Yes.
Okay, with this search warrant, right?
Yes.
Okay. Did my client participate in you going through, well, you had a chance to go through and look at hours of videotape, correct?
Correct.
And he didn't stop you at all from taking the videotape. You asked for it, and he showed you where it was, and he gave it to you, correct? My client's husband.
Correct.
Okay. And you didn't have him come to your office and go through the videotape from start to finish to confirm that that's the videotape, no editing, no nothing, that it's the full videotape. Did you ever have him come do that?
He did not come to my office, no.
But you never went through the entire videotape with him prior to you starting to edit and show certain fragments today, correct? He didn't participate in editing this, correct?
It's not edited. It's just the videos were taken off of the DVR.
Okay. If the DVR has 6 hours of recording and you take 2 or 3 spots, segments, that would be editing, right? Because it's like taking a police report and putting black certain parts.
I can't say one way or another. I don't believe
Is that
so.
the full videotape?
Is that the full
Full
contents
videotape
of?
of
Yeah, hang on a second, ask him the question.
Okay.
Talk over.
Not
You're right.
relevant.
That is not the full contents of all the video for that day. No.
And who decided to participate in, for lack of a better word, editing or picking which versions and how they were obtained? Who did that? Did you do that? Did an IT person do it?
No, I looked through all the video footage.
And you picked those to bring to court today, right?
Yeah.
I notified the prosecutor's office of my findings.
Okay. And your job is to participate in people that are arrested and participate in coming to court and participate in getting convictions. Do you agree with that? You're not here.
Getting the truth out.
That's not argumentative. How's that argumentative, Judge?
Your job is in getting convictions.
Well, what's he doing here today? Is he working for me and saying
I
she's
think what he's
innocent?
doing is telling the truth.
Yeah.
Okay.
That's his job. So in that regard, the
I
objection
missed that bit.
is sustained.
Okay.
Oh, that's gold. Well, I'm sorry, I missed that bit. I heard the spicy bit, but I wasn't listening, obviously. So there you have it. Yeah, throw away that key, mofos. Throw away that key. So, for those that have just joined us, Marshella, guilty as charged on all counts. She'll be sentenced on the 15th of May. Hopefully they are consecutive and not concurrent. And she has a tendency to sleep on her belly with a celly. Yep. I'm going to have to cut that bit out and put it in a short. That's gold. He's in the business of telling the truth. Can I I'm going to do something really, really funny. Yep, you wait for it. Stay tuned. It's gold. Oh, my noggin's evil. All right, well, I'm going to keep continuing working on my next presentation. What's today? Oh, it's Friday, isn't it? Friday. We have a new trial starting on Monday. Hopefully it's you weren't here last week, Tricia, on Monday or the week before. I had a trial set ready to go Monday, had it all prepped, had all my research, had the thumbnail up. I had it up for 3 days before the actual stream. I had overlay, I had everything organized. About 2 hours before I went live, Steve messaged me on Facebook and said, that trial's out of Maryland in Baltimore. They don't normally live stream. Even though I got the details from Court TV. Sure as shit. So I went to plan B, which was this one. And it was a choice of this one or the judge. And I'd swiped left on both of them. So, yeah. So I set up for this one, started streaming. Shit. They're doing jury instructions. Not jury selection. So I had to set up for a third stream. And just covered the Brian Walsh hearing, which was really crap. But yeah, that was my Monday. So hopefully next Monday we have. Actually, do I have a sneak peek on this one? This is the. Let me have a look. I might have a little tidbit for you. Little bit of a tit. Let me go to my channel. My playlists. All right. I think this is the one. Yes, the Connecticut killer. All right, let me put a teaser on. Oops. All right. Full screen and why is it? Okay.
Just your reaction.
I'm myself and the family are content with going to trial because now we can prove that Jose committed the crime, and there will be justice for my sister-in-law, Christine.
It's very emotional.
It's been a long 4.5 years to get to this point. There is family members that have liked to speak their mind today to the court, but we knew going in there was a possibility that we didn't have that opportunity.
Were you ever given the specifics of what the proposal was from the state or the
I can't
counteroffer?
speak on that. That has to come from the state.
What, when you say family members would have liked to speak today?
We have family members from Nashville that are here today, from Philly, that have come out to support the family.
Did you expect that there was going?
Our top story tonight, 4.5 years after an Ansonia mom's murder.
Oh, yeah.
Her alleged killer will head to trial. This comes after Jose Morales did not take a plea deal today. News 12 Connecticut's Marissa Alter reports from Milford Superior Court.
Jose Morales walked into court smiling and waved at the judge. His behavior just added to the continued frustration felt by the family of Christine Holloway.
That's part of the anger, because he, in his mind, and I already know, he thinks he's going to get away with it.
It will now be up to a jury to decide whether Jose Morales killed the mother of his infant child. In December 2019, Ansonia police discovered Christine Holloway beaten to death inside her home and no sign of 1-year-old Vanessa Morales. Jose Morales is suspected in his daughter's disappearance, but has only been charged with Holloway's murder. On Tuesday, the judge put the case on the trial list after both sides couldn't agree on a plea deal. Details of the offer weren't made public.
Myself and the family are content with going to trial.
Yeah.
Because now.
All right. So that's next week's, starting Monday. I believe that jury selection was done a couple of weeks ago, so that's good. So stay tuned for that one. Hopefully that's not going to be a shit show on Monday like it was last week. Now, Mr. Udaher, I have a proposition for you. Should you choose to accept it? Oh, really? He's interviewing a juror. All right. So, I was... No, you're not in trouble. Not at all. No. No, I was just thinking the other day, I'm like, this trial's going to go on for how long? At least 4 weeks. Are we gonna get at it every day for 4 weeks? Because I don't know if I've got it in me. So I've come up with a potential solution. Now, whilst we don't agree on guilt or innocence, that's neither here nor there. What I thought we could do, because I know I can appreciate, I can give credit where credit's due. So what I thought we could do, watching that hearing yesterday, especially towards the end, the actual caliber of lawyering in this case is phenomenal. All right, I might not agree with his tactics or the way he goes about it, but it's bringing out that it's fireworks between these two. And I think we approach this trial on just not evaluating, but like just being, what do you call it? think of the word. Appreciative of the level and the caliber of lawyers in the argument and the argument itself. Like, I think that might be a really good approach when it comes to time to trial, because I think we're in for fireworks big time. I really do. And I think we've seen little hints of it. And yes, yeah, focus on the lawyers' arguments and their strategies and what they're doing, and whether that was a good point or, like, because you compare, even just in looking in these motion hearings, there is no comparison between him and Lally at all. Yes. Yes. And I think it'll be a wicked showdown, if not like between these two, because they're both alphas. They both won't back down. They'll double down. And I think we're in for, and I know that sounds awful because there's someone's life at stake here, but I think if we approach it like that, then we're not going to be wanting to strangle each other after 4 weeks. How does that sound? That fair? Virtual shake? And then we'll have to come up with a reward at the end for the winner. Did you see the get up? Did you see the verdict on the DUI trial? I hadn't actually seen the footage. I must have been daydreaming. But they had a video of her before and well, they had in rebuttal. All right. So in rebuttal, the state brings out a receipt. 9:01 a.m. that day, the day of the incident, she's at the bottle shop, and she bought the little 130 ml bottles of wine and a normal sized bottle of wine. But I only had one drink. So they had testimony that she only did have one drink at the bar. And so, yeah, the rebuttal brings out this, the receipt of the wine. They find one of them empty in the center console. And then they have the ultimate self-snitch. She's got internal CCTV footage of her consuming alcohol both before and after, right up until 2:30. Before, like, she refills her last glass at 2:30, and she heads out at 3 p.m. Yeah. Apparently, it was under 2 hours. I don't even know what. It took them longer than half an hour. They probably had to go to the toilet and have something to eat and fill out the paperwork. Yeah. So she's charged with 2 counts of second degree. And I can't remember how many counts of intent and injury or something like that. Yeah. So I hope she gets consecutive sentences, because she should not have been able to go to trial. The defense was trying to say that she was in the middle of a seizure, and when she backed out and hit that car, that jolted her arm and put the car into drive. Fuck me. Be interesting to see if it was actually a manual. Anywho, so that's it for that trial. That worked out quite well, actually. It was just stupid because it wasn't streamed on a big channel. It was bits and pieces here and there, so I apologise. So day 3 has 3 parts to it. Just to pure doubt. Absolutely. Abso-freaking-lutely. Yes. Yes. And, you know, the testimony of the bar, of the waitress in the bar, if she says, oh, no, she was pissed, well, responsible service of alcohol out the door. And if you're a seasoned drinker, which she obviously is, you can feign sober like nothing else. And her BAC was 1.18, and that was taken how many hours after the incident? So she was way on the way down. Yeah, she deserves to be stood in a boat club and have a car driven at her. Sorry. See, this is where I reckon if you're that's awful, like the old eye for an eye, you know. If you're found guilty, for whatever heinous act, then that's the way that you should be treated. Anyway, I will be putting out one more presentation over the weekend. I'm trialing doing a bit of a storytelling true crime thing. So I found a case from start to finish, and I'll just do a from start to finish overall description of it, and I've created a new segment. Did you see my video before, Tricia? So the new channel segment is called, and this is where I'm going to put all the presentations of like different true crime incidents and stories and stuff. So it's called Let's All Get Up in Show Business. This is my intro.
So get up in show business.
I know, I'm an idiot. And I think my my catchphrase for the introduction will be something like, oh, let's dissect this case, or something like show business style, or let's something like that. Let's chop it up, shall we? I know, I'm sick, but I amused myself. Have you missed me, Tricia? Oh dear. All right, so yes, I'll put that the first piece of show business out this weekend. I should put that in my merch, make a t-shirt out of it. Let's all get up in show business. I'll get a hat. Oh Christ. Yep, it's nearly 5 a.m. Okay. I shall be looking at you within at least 2 more sleeps. You have yourselves a fantastic weekend. It's going to be warm here. It's been warm all week. I will be watering my garden because we haven't had any rain for so long. Yeah. So, with that, I look forward to seeing you Monday. Don't be good. Be good at it. Bye-bye.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.